Welcome to the Substack, or as I like to call it, the Stack. How are you finding it so far, Professor?
I am having a great time. I've been at it for just about 2 weeks now, and
Mhm.
I love having a place where when I share ideas, which I have been doing a lot, I get immediate feedback. And I also love being a little looser in what I write than what you do in a book or even in a Bloomberg column, which tends to be, here is the law, here is how the Trump administration has violated the law, and here is how we ought to change things to make it work better, which is great and, rinse and repeat and do for the next 3 more years. But it's fun to talk about other things and with greater depth.
Well, here, this is a footnote-free zone.
There you go. So I
So,
should say things without attribution or citation. No?
um, no, you should say things with attribution and citation, if you feel you must. If you feel you must. Um, are a lot of your colleagues on Substack?
A growing number, I would say. Still not that many, but I sense a kind of groundswell. And of course, that worries me. Once the law professors get involved, the whole thing may be about to crash.
Then you got to go somewhere else. Now, are there some people, you don't have to name names unless you want to, who, at the very esteemed Harvard Law School, look down at your participation in such a public forum?
I think my colleagues are used to my being willing to share ideas anywhere under any
Yeah.
circumstances. And whatever feelings of doubt they have about that and skepticism, they've had for long enough that they've kind of, grown to be part of the furniture.
It's sort of interesting. And then we'll get into some substantive things that you've been thinking about and writing about and teaching. I just had a conversation with a historian, legal historian, who's a friend of mine. And I have a lot of historians on the podcast, but there are many historians probably who don't appear on podcasts and don't do popular biographies and works of history. And I think it's a great thing. I actually think more members of academia should participate in the public square in places where ordinary people who are not experts can listen to them and hear what they have to say, as long as they're speaking in a plain way without being condescending. Why do so few do it?
I think it has to do with the training. They
Mhm.
spend so much time in training for any academic profession, teaching you a technical language that's designed to express something precisely and beating you up when you're imprecise, that then when you go out into the wild, people are worried that they'll sound stupid. And of course, the simple answer to that is there's just different registers of talking that we use in all different
Yeah.
contexts of our lives. And I've been doing public communication aspects since the very day I first became an academic, mostly because my second week of teaching at NYU as a baby professor was 9/11. And I had done a
Oh, is that
PhD in
right?
Islam,
I didn't
and,
know.
and I had done a PhD in Islamic studies that no one was interested in the law world at all when they hired
Right.
me a few months
Yeah.
previously. And then the dean walked into my office, when we finally came back to the office and said, "Did you say something about Islam?" And I said, "Yeah, you were totally uninterested." And he's like, "Well, that's changed now. So now we're interested." So I just think you have to suck it up and accept that some people in your profession will say, "But that was imprecise," and be like, "You're right. It was imprecise. But if you look in my book, I tried to say it in a very precise way there."
How did you come up with a very clever name for your Substack? Professor Noah Feldman's Substack. Did that take
Yes,
you a long time,
it
Professor?
actually it took a lot of effort and a lot of market research. And I think the most
Used
interesting
AI.
conversation.
Clearly, AI was used.
No, because there's no M dashes and it's not a Substack, it's a whatever. So definitely it wasn't
Welcome to
AI.
Professor Noah Feldman's Substack. No, it's very catchy. I think it's very good. You wrote, I think this was in your opening salvo on the
Mhm.
Stack. I want to ask you about it. What I'll be sharing here is what you might call actionable wisdom. I like the sound of that. What is actionable wisdom?
Actionable wisdom is a way of seeing something, whether it's an experience or a feeling or a fact about the world or a theory, that enables you actually to do something with what you now know. And the thing you can do with it can start, I think, with being aware of your options, being aware of how you can affect the world around you, and also being aware of the limitations of how you can affect the world around you. And that's where wisdom begins. It begins in some recognition of our capacity to exercise our own agency. And if you do that, then I think you also get the added benefit of feeling a little bit better about yourself. You feel that you've understood something and that you're able to do something in the world. And you're also not going to beat yourself up for not doing what's beyond your power to do.
So let's take an example. I'm skipping over what I thought I was going to talk about first.
Sure.
Minnesota, Minneapolis, ICE agents, and you've written about some of the things that I've talked about in the podcast also,
Yep.
that this somehow has now become an agency with masked agents and secret memos, which, as you have written, un-American, and I agree. Give us in a snapshot how you think that has played out, and then what is actionable wisdom people can take away from what you have to say.
Absolutely. And maybe if it's okay, Preet, I'll take them in a reverse order.
Yeah, please.
What we learned from the whole horrible episode in Minnesota, not that we're sure that it's over, but it seems, at least for the moment, to be better than it was,
Yeah.
is that sustained public civilian objection to what was happening had an enormous impact on the events. And so if you ask, what can I do in any given moment about what Donald Trump is doing with ICE? What you can do, no matter who you are, is in whatever domain of life where you're operating, continue to consistently and calmly or uncalmly, that's up to you, express that this is not normal, that it's not okay, that it violates our principles, that it violates our laws, and don't stop saying it. And so that's what's actionable. And if you ask me sort of what's the bigger picture about why this worked, what I would just say is the conditions for the emergence of autocracy or authoritarianism or totalitarianism happen when the people who are on the fence look around and say, no one else is objecting. And if anyone does object, they get grabbed up and bad things happen to them. And so maybe I should just acquiesce. And then you can get the acquiescence where even a democratic system can be undermined and eventually eroded to the point of collapsing. But if people are speaking out on a regular basis and you look around and they're not stopping, and whatever government efforts are being engaged in to stop them, including, obviously in Minnesota, the two people being killed,
Yeah.
and people are continuing anyway, the message to everybody is, we don't live in an autocracy. We don't live in an authoritarian state. And that message is crucial to preserving democracy.
So I want to ask you about the Fourth Amendment in a moment, but since I have you, I want to ask you a totally unfair question that I sometimes ask my own students at NYU.
Best kind.
If you had to pick one amendment in the Bill of Rights that's most protective of liberty, could you pick one?
Yeah. I'm biased because I teach First Amendment.
Yeah.
And
But the First Amendment has multiple provisions. Can you pick
it does.
which
Yeah.
one?
Yeah. I would take freedom of speech in the press. And it doesn't have to be in the press. It can just be speech. That's sufficient if you want to take speech in the press or two different ones. And the reason is partly what I was just saying. If you are able to speak out in a consistent way, you can demonstrate that lots of people are speaking out, and then you can preserve the possibility of democratic action to change the course of what government is doing. And so even if someone has their Fourth Amendment rights violated and they're arrested when they shouldn't be, and their privacy has been violated and everyone's afraid of government intervention, saying it loudly many, many times, many, many people saying that can have an effect of eventually reversing that. Whereas if you couldn't speak out about it, no one would be able to get the message that things were wrong and that people were resisting.
So that's a good segue, awkward as I'll make it, to use your and my First Amendment right and privilege to talk about violations of the Fourth Amendment. Remind people what the Fourth Amendment is, why it's important, and why we are talking about it in connection with ICE and a secret memo that I mentioned earlier.
Well, the Fourth Amendment protects all of us, the whole people, it says the people, against unreasonable searches and seizures, which basically means being either grabbed up and arrested, or alternatively having the government break down your door and come into your home without a warrant. And when you say warrant, we're going to talk about a warrant and what a warrant is. But by warrant, the framers meant a decision made by an independent decision maker, like a judge, that says there is probable cause to believe that the person being investigated has done the thing they're being investigated for, or that the evidence is in this place. And without that, you don't have a warrant. And without that, you can't arrest someone or enter their home.
Now, ICE has taken the position, contrary to what most of us have understood the law of the Fourth Amendment to be, that they can go into people's homes without a warrant authorized and signed by a judicial officer, as you describe it, but some internal check and balance, such as it is, to do that, what's interesting, so two parts of this. One is that lawful and constitutional, Professor? And second, if it is, why have the memo justifying it remain secret? Isn't that a hint and a half about the dubiousness of the memo?
Yeah, I mean, the memo is wrong and
But you've not seen
obviously
the memo.
wrong.
Have we seen the memo?
Well, no, we've seen the chunks of the memo that make the relevant argument have been
Okay.
leaked. Yes, and I read them, and they're out there. Um, so part of what's going on here is that there's almost like a play on words. There's something called an administrative warrant, which I now believe, I never really thought about this before, that it shouldn't even be called
It's
a
not a
warrant.
warrant.
Yeah, it's not a
It's a,
warrant in the
it's a
legal sense that
memo.
you as a prosecutor
Yeah.
would have recognized, because an administrative warrant doesn't require that there be a third party independent fact finder like a judge who looks at information that's brought to him by a government officer. So that's not a warrant in the modern legal sense of the term warrant. And
Yeah.
so what they said in this memo was, because under some conditions, ICE agents are allowed to arrest people who are suspected of being undocumented, um, without a judicial warrant, that by extension, they can come into your house to look for a person like that without a judicial warrant. And that just flatly runs in the face of the Fourth Amendment, which just says that they can't do that. So that's the first thing that's wrong with it.
Yeah.
And then the second thing that's really obviously wrong with it, which I think is worth mentioning, is this: if that were true, if that were the rule, then anytime any government agency wanted to get into your house, it would be enough for them to say just to themselves, well, we think someone is violating our regulations here, and so we can come in. And so then the FBI or the cops would be like, great, we'll trail along when you make that entrance. And that would literally be the end of the Fourth Amendment. So not only is it obviously not the law, it can't be the law. And as for it being secret, I mean, that is honestly about as bad as it gets. For many years, going all the way back to, really to the Bush administration, the W. Bush administration, and the Patriot Act, I've been on the hobby horse of saying, if something is secret, it's not the law. The very definition of a law is that we all can have access to what the law is, so we can conform our behavior to it, or not, I
Yeah.
guess.
You
So
need
if,
to have
if it's a secret,
notice.
there's no such thing as secret law. If it's a secret law, it's not a law.
Do we know from the leaks of the memo who the human authors are?
It's not titled with a name, but it did come from the top brass at ICE. So it came from that office.
And I'm not asking you to make accusations of ethical violations, but um, do you have a view of the person or persons who um, would have pride of authorship in such a document?
Look, if you're writing a memo like that, you seem to be prepared to go against the most fundamental Fourth Amendment protections. But this memo tried to make a legal argument on that basis. And they also, first, according to reports, deployed this in the Fifth Circuit, because there is an opinion by a Fifth Circuit panel in which one of the judges says in dicta that maybe we could soften ordinary Fourth Amendment requirements in these circumstances. And that's what they hang their hats on. It's not going to win in a court. Might it save the person who wrote it from being sanctioned by the Bar Association? Maybe.
Yeah. Look, there are all sorts of rights and procedures and policies that have exceptions to them developed judicially. So, for example, the Miranda warning, which, by the way, came a couple of hundred years into the Republic, right? So everyone understands the Fifth Amendment came at the start. What does it mean to have a right against self-incrimination? Well, many, 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 many decades, century and a half to 2 centuries later, everyone now understands if you watch any police procedural, that means you advise someone of their rights, which everyone understands is a Miranda warning, which, by the way, has been controversial for a long time. But in recent years, it's sort of settled and appreciated and adopted, I think, also by the mass of folks in law enforcement. But there is a rule that in certain exigent circumstances, if you're trying to find out, if the person who you've detained has associates and there are other people who are prepared to commit violence, usually in the case of an operational terrorist, then you don't have to Mirandize. So in some circumstances that makes sense, but usually it's the case, is it not, that that those things are justified based on extreme, present and imminent danger to people around them. Is there any of that argument with respect to the folks who wrote the memo saying you can go into someone's house? Like, what's the
No.
urgency there?
Yeah, there is no urgency, and they didn't even claim urgency in the
Yeah.
memo. Yeah, I mean, they did something slightly analogous. ICE did something slightly analogous in a different secret memo, if you can believe that there's another one, which has to do with
Secret memos like
whether they.
company, Noah.
Yeah, I guess you're right. That's right. I got to hang out in more circles where they write them.
Yeah.
Which is they also have a memo saying that with respect to street stops that ICE engages in, which the statute requires an administrative warrant for the street stops unless the person is a flight risk, unless the person and they wrote a memo saying we've been misinterpreting flight risk for all these years because we've always interpreted flight risk to mean that if we stop you and we give you a summons to appear, a flight risk means you're not going to appear. But now they said we changed our interpretation. We were wrong about it all these years. What it really means is if you're not going to hang around for the conversation with the ICE agents, then we can just grab you up without an administrative warrant, which would mean they could stop anyone because pretty much anyone who's stopped by ICE and is told you can walk away is going to walk away. So that's another extension. And that I think is a misreading of the statute. That's not a constitutional violation, but it is a statutory violation.
Let me ask you this question. Do you believe that when the people wrote the secret memo that they were also wearing masks?
Huh. Yeah, I mean, literally they were, because if your name's not on the memo, that's what it is to write that's what it is to wear a mask when you're sitting behind your desk. It's to not sign the document you wrote.
I'm making a point with a poor joke, but
no, it's not. You're right. That's not even a joke.
Is there any justification for the mask thing?
I would say personally, no. I don't think there's any justification. The claim that somehow this is about protecting
they're being doxxed.
People against being doxxed. Yeah, I mean, on that theory, every single member of law enforcement could make the same argument. Every prosecutor. I mean, when you were U.S. attorney, everyone knew that you were the U.S. attorney. That's part of being a public servant. And does that mean you didn't get crazy letters? I'm sure you did. Does that mean you didn't get threatened by criminals? I'm sure you did. Yeah, there you go.
Professor.
Yeah.
You make a point that I'm very appreciative about, because lots and lots of people, and then I'll let you go back to class and your work. People love to use the word unprecedented. And I see people use it in their legal papers, and they don't do the extra work of saying whether or not the unprecedented thing that they're talking about is good or bad. And so even when it's the case that people point out something they think is bad that the Trump administration has done, unprecedented itself is not a normative word. And as you point out, I thought in a great piece, the doing away with slavery, giving women the suffrage, the right to vote. Many of those things have been unprecedented at the time that they happen, but those are good things.
Yeah.
Why did you feel the need to write about that?
I felt the need to write about it because lots of people, and I include myself, because I went and reviewed my own columns in the past to make sure, to find out if I was guilty of this, and I was. We have a tendency to look at things the Trump administration is doing and insist correctly that they're unprecedented, and then sort of leave it there as though that were enough arguing. And like you just said, it's not enough arguing, because something could be unprecedented and good. And it also suggests that sort of like, once it's happened, now it's not unprecedented anymore.
Right.
So then the next time it happens, it's somehow supposed to be okay. So that's also not good.
Right.
So the reminder to myself was, don't just say this is unprecedented. Explain, if it's unprecedented, why we've never done it before, why we had a good reason for not doing it before, and why we shouldn't do it in the future, even though now that we've done it, it would be precedented.
Yeah, I see people on TV do it all the time. And they think that their message is sufficient by just saying unprecedented. So thank you for that. I got to let you go, I think. How are your law students doing? I'm sorry. Let me ask you this question.
Yeah.
I don't think I've gotten asked, and I ask this of law professors, because you teach constitutional law among other things.
I do.
And have you taught con law every year for the last several years?
I have.
Okay. What degree of revision have you had to do to the syllabus each year for the last few years as compared to some years ago? In other words, how much transformation has there been in constitutional law such that you teaching first-year students have to engage in radical change of your syllabus and your teaching?
The field is in total revolution. And, that's been true over the last 5 years since we got a conservative majority on the court and the judicial revolution began. And I don't just, teach my con law class and have to revise the syllabus. I also publish a case book, the
Right.
blue
Oh,
case
right.
book,
Yeah.
and that has to be radically
Yeah.
rewritten. And,
You thought that was a good cushy gig, didn't you? Like, you
not
tinkered
not
with it a
cushy.
little bit. It's a nice annuity, and now you have to do real
Yeah.
work, sir.
And then the other thing I was going to say, Preet, is that when it comes to First Amendment,
Yeah.
during the semester, last semester, when I was literally teaching the course was changing, because we had the Jimmy Kimmel episode, we had the
Yeah.
chairman of the FCC saying you can do this the easy way or the hard way. And this stuff is happening. And so I think the students are doing great in the sense that the students care and they're engaged and they're trying to keep up. It's the system that is not doing as well as it should.
Yeah. So thank you for teaching. And thank you also. I said this to you before we went live. I think it's really great that you're in the public square and not confining your wisdom, your actionable wisdom, just to people who are paying an enormous tuition at the law school, but also sharing it with the public. It's really great. Welcome to the stack.
Thank you. Thank you.
And I hope we can do this again from time to time.
Likewise.
Thanks so much.
Anytime. Be well.
All right, let me see if I know how to turn this off.
Okay.
Folks, get back to work. Okay, bye.